Thank you. Good morning, everyone. This hearing is in the matter of case number CFI 046-2023 and is being held by way of video conference before Justice Sir Jeremy Cooke. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Al Tamimi and Company. Lead counsel is Mr. David Holloway. The defendant is represented by Sol International Limited. Lead counsel is Ms. Sarah Malik. Thank you.
Yes. So, Ms. Malik, I assume you want to say something.
Thank you. Good morning. Yes, Your Honour. You hopefully will have seen our email of this morning.
Yes.
I'm grateful. I do start by saying I don't bring this application lightly, and I'm fully aware of the circumstances that we present ourselves in. Just by way of background, as I've set out, we were instructed very late last night on this matter. And I did explain, and I'm only here before the court today to assist only for a postponement application. If that's not granted, I'm not in a position to proceed, and the client knows that. By way of background, and I've had obviously very limited information. I have had a document sent to me. I know I'm in an unusual position of asking for a postponement of a permission to appeal application that's been made by my clients. Nonetheless, as you're well aware, the court is well aware, Your Honour, that there's been previous representation on this matter, which is not an insignificant matter, for a number of months. And they recently came off record only in May. We've seen the orders. The background is set out. It was only yesterday that the application to postpone today's hearing, as I understand, at 3 o'clock was decided against my client. And it's thereafter that they've contacted me, spoken to me at some length. Once I've been comfortable to make this application, I've come on record or going through the formalities. Obviously, there's been no formal application made, and we do rely on 23.7 in terms of the urgency, and that's the only reason it's not. We're trying to circumvent applications being made to the court. And also within the email, you'll see that the provisions we rely on largely the overriding objective and the court's inherent case management powers at 4.2.2. I know I don't need to explain the full background in terms of the importance of this matter and where we're at, and the fact that the matter is also before, as I understand, the Joint Judicial Committee. But so I'm not sure what now temporarily was removed.
You froze at the point of talking about the Judicial Committee.
Oh, okay. I was temporarily stopped. I've just said I do understand the wider importance of this matter as well. So the issue, obviously, before the court today is going ahead vis-a-vis the claimant representing themselves, and I'm not sure even if he's on this call or if he is represented by anybody lay, and I don't think that is the case, and making a decision, and we say that that cannot serve the best interests either of either party or even the court. It's not a due process, we say, and I take that knowing the background, but in terms of the claimant being able to properly represent himself or to have proper legal representation, going ahead on the matter today without that is fundamentally critical to his status. He's fundamentally prejudiced. I don't think I can say much more. I do ask the court for the indulgence. In terms of a return date or otherwise, again, my position is I do need to take fuller instructions. I need to get on top of everything and revert to the court as soon as possible within a matter of days as to a date that, you know, could potentially the court could indulge on the other side, and that's not going to be a date that's, you know, far away in the future. I hope, Your Honour, you do appreciate the position. I find myself in as counsel. I do make the application. I do strongly believe in the application. It's not just an application for any delay tactics or otherwise. I have read some of the history. I do understand the other side's position and what they will say. I have no doubt that this is just another tactic of trying to stall. But this is a position where it is my client's application, not the other side. And as I say, it is a rather unusual application to ask for that to be postponed, but there are good reasons behind it. If I may assist you no further, those are my submissions at this stage.
Apart from what you've said, what are the other good reasons? It's going to be said that your client is simply playing the system. I understand your position entirely, coming on the record, well, not even on the record, but being instructed last night. But on the face of it, your client was represented, solicitors who were involved, counsel who was involved in drawing up grounds of appeal and a skeleton argument for permission to appeal. And they applied to come off the record on the 8th of May. They come off on the 13th of May. That's 2 weeks ago. What's your client been doing?
In respect of obtaining alternative legal representation?
Yes. Yes.
As I
and you know, why have the solicitors come off the record?
Okay, I'm not going to mislead the court and say I know why they've come off record, because I don't. That's as I understand, there's reasons between the client and the lawyer. Certainly, they are the ones, you know, as you say, who submitted everything.
Well, I know why they've come off the record, of course.
Well, I'm not, as I say, Your Honour, I'm not in a position to mislead or say anything that I'm not aware of. And secondly, in terms of, you know, what it's been doing in the last 2 weeks, you will appreciate, and I have, again, at a very high level, seen the emails that have gone to and fro. My clients have attempted to, well, contact the court to make their application without legal representation, to say, you know, we do need some time, that we do need some time to get legal representation. They have contacted me, obviously, it was yesterday. They have contacted me previously. Again, I will not mislead the court. I wasn't instructed, but I was contacted previously on this matter. In respect of, you know, would I have availability or otherwise to take on new work, but that nothing further was discussed. So I don't know the ins and outs of who else they've spoken to, whether they've tried to procure the counsel, but they certainly haven't just attempted to secure somebody at the last minute, last hour. I think, given that the application was refused, and it was refused so late and without reason, because obviously I asked for the documents as in terms of, you know, whether there's any reasoning as to why it was dismissed, and that quite rightly, I'm going to say, felt that, well, in order to protect their position, they do need to immediately then instruct, at least for the postponement application this morning. So if you're looking for other grounds, I'm just going to say that given the volume, given the amount that's not in dispute, but the amount that this case entails, given that it's a matter of some importance, it's a matter that's before the Judicial Committee, because as I understand, and I stand to be corrected, as I say, I've had limited time on this matter, but as I understand, the judgment that's been made against my client is now, and the DIC court tasked to enforce it, is now the enforcement appears to be through the second defendant, or at least the sale of shares of the second defendant. And that's the issue that's of the claimant's position. Obviously, that's something that goes beyond the jurisdiction of the DFC courts. It's a matter that's before the Judicial Committee. And the problem is that's an irrevocable transfer if that takes place, a sale of shares. So it's rather important. The right arguments do need to be canvassed in front of you. I haven't had the opportunity to go through even the skeleton arguments of both sides, take proper instructions, and as counsel on obviously rules of UK bar, etc. Ethically, I am not going to mislead the court, and I'm bound to tell you exactly my position and where I stand. And I'm apologise if I can assist no further, but I do solidly believe that there are good grounds to postpone this matter, given the overall wider importance and the importance of having seasoned, experienced counsel and canvassing these arguments, as opposed to a lay person or none at all.
Well, your belief, I'm afraid, is neither here nor there, and that's not something you should be telling the court. Counsel make submissions to the court. They don't express their views or their beliefs. Let me just say that. That's for your education, but I don't hold that against you in any sense of the word, Ms. Malik. Now,
I'm grateful.
And I understand entirely your position and what you say, but the position is this, that I don't have an explanation of any kind from the defendants themselves, who have made applications to the court in person, so to speak, by Ms. Mansour, no explanation as to why Charles Russell Speechless came off the record, have no details of any efforts to obtain other representation at all in the time available, no explanation as to why counsel, who had drafted the grounds of appeal and skeleton argument, could not appear instructed by someone else at very short notice. None of it makes any sense at all. And I'm bound to say, I think your client is stalling for time, is playing the system, and that's consonant with a whole history that has gone before since the original contempt of court back in February of last year. And there is this question, Miss Malik, which I haven't asked you thus far, which is why I should listen to you at all when your client is in contempt of court and has failed to purge that contempt, despite being given every opportunity to do so over the past year and 3 months.
And Your Honour, again, I'm not trying to hide behind anything. I'm not instructed. I don't know the ins and outs done on behind. I'm simply instructed as counsel. When you say I'm not on record, it's actually, we've been speaking to registry this morning. There's some issue where they haven't had the practicing certificates in the wrong file. That approval is coming right now.
Well, I understand.
Part two of the event. I'm grateful.
All right. Well, Mr. Holloway, what do you want to say?
Just two very short things, my lord, because you know the background very well. The first is that this application you've already decided it yesterday, and there's nothing that's been said that adds anything else to what you had in your mind when you already dismissed the application yesterday, apart from the fact that Ms. Malik was only contacted late last night after close of business, which is the only piece of evidence that we've seen of the defendant trying to get legal representation since Charles Russell removed themselves in early May. That would just simply add to the reasons why there shouldn't be any further adjournments. I'm not going to say anything else, my lord. I think the position is quite clear.
Yes. Well, Ms. Malik, I understand your position entirely, but I'm going to refuse your application. The reasons are very simple, and they are these. First, your client is in unpurged contempt of court, having failed to abide by disclosure orders made in February of last year, having been given the opportunity to purge that contempt on a number of occasions, and having failed to do so. I know there is some evidence of significant illness at various points, but in the course of a year and a quarter, and given that Miss Mansour has been able to file witness statements on his behalf and has his power of attorney, and it was perfectly possible for counsel to file both grounds of appeal and skeleton argument in relation to seeking permission to appeal. Put that all together with Charles Russell Speechley coming off the record 2 weeks ago, following an application made on the 8th of May, which remains wholly unexplained, and therefore the inevitable inference is that they came off the record on the basis that their fees had not been paid, and no explanation at all being given by the defendants for failure to engage other solicitors or the same counsel to continue with the appeal. I can see no possible basis upon which I could rightly grant a further adjournment. In my judgment, the defendants are playing the system, have decided that they're going to do everything they can to stall and stymie this court's process, and therefore, particularly as it's their application for permission to appeal, and it's they who should be pursuing it, I see no basis for an adjournment or a stay of any kind. So your application is dismissed for the reasons I've just given. Thank you very much, Ms. Malik. Whether you wish to attend, what you wish to do next is, of course, entirely a matter for you.
I'm not actually instructed to attend. I'm grateful, my lord. I've taken a short note, and we'll get a reasoned decision. It seems that the court's mind is already made up, and I was instructed to put this forward, and
No,
we'll
no,
see what
don't. I understand you have a professional duty. What I said earlier, by way of what you should submit, is by way of education, not by way of reproof. All
no,
right.
it's 25 years in. I'm grateful for that education.
Well, I'm surprised that you haven't picked that up before. But the one thing counsel should never do is say that I believe this case to be right. You make submissions to the court. You don't express your own views ever.
I think the view was that it's a case of much wider importance, and I think.
Well, I understand that, and that's the question that I and the Judicial Committee and other places will have to decide, no doubt. But that doesn't excuse your client's performance and the actions he's taken. But there it is.
And I guess, my lord, you may well not entertain, but if there was even a short adjournment to get you that information of any steps that have been taken, that wouldn't sway you either way in any event, it seems.
It's too late. It should all have been done long ago. The whole point of this exercise, as far as I can see it from the defendant's perspective, is to push this off into the middle distance, which is what he's been trying to do all the way along. Now, of course, he might be right or wrong about some of the points that he's raised, but that's a different matter.
I know, my lord. We hear that because it appears that was your mindset when I addressed you. So I'm grateful. Thank you.
All right. Well, thank you very much.
May I have the leave of the court? That may be excused.
Yes, of course. Thank you very much.
Thank you.
Right, Mr. Holloway.
Well,
where do we go next?
Well, since the permission to appeal is not being advanced, as far as I understand it, then that falls to be dismissed, that application.
Yes.
And then we come back to the second matter, which was on the list today, which is the contempt issue and further sanction for contempt.
Yes. Well, it seems to me the appeal must be dismissed on the basis that it's not being advanced today, and not being advanced by what must be a clear decision not to advance it in the circumstances that I've just outlined in refusing an adjournment or stay. Yes. So yes, I may want to say something further about that in a short written set of reasons.
Yes.
In relation to the substance of the permission to appeal, in case this matter should go further and permission be sought from the Court of Appeal. But
my lord, that in my submission would be extremely helpful in the event that it is looked at later, and if there's anything I can assist you with on that, I am happy to do so.
Well, perhaps we can come back to that, but essentially your arguments are in your skeleton. There's nothing new, is there, that appears above and beyond the skeleton argument?
No, my lord, not going to, and most of that you've already heard on the 15th of December at great length. Yes.
All right. Now, the difficulty I have is this, that you want to move on now to sanctions for contempt in a context where we now have an unrepresented pair of defendants.
Yes, my lord.
How does that impact on the position?
Firstly, we were moving that application only in relation to the first defendant presently, and I appreciate the difficulty. My lord, we had at the original contempt hearing, I believe your lordship had in mind the sanction that you imposed, the purpose of which was to do everything possible to encourage compliance with the freezing order. It seems like we've moved beyond that point, really. That's my only submission to
Well,
add.
let me tell you what I was wondering about, and that was to impose a significant fine unless the contempt is purged within, let's say, 7 days.
Or yes,
It gives it's a last chance saloon, if you like.
Another one, indeed. Well, yes.
Indeed, but it is then got behind it a very clear sanction, because the fine will then become payable in the absence of compliance. Now, it may or may not have any effect, but at the end of the day, both the court, in the interests of its own process, and you are concerned with having the disclosure and getting the necessary information that you need. Now, obviously, you can get a degree of information from other sources, as we know, but it would be much better for the contempt to be purged.
Yes.
So what do you say about that as a potential solution for the moment?
We're not, as I think Mr. Anderson and your lordship discussed at the last hearing, we're not. It's not our job really to push for particular sanctions, indeed. But what your lordship suggests seems eminently sensible, particularly with the unless order aspect of it, because it may be that that lawyers are instructed and compliance happens. So that, you know, we've that sounds like a perfectly sensible suggestion. The only other point that I wish to make is to revive something that was discussed at the last hearing, which was fixing a time limit for payment of the judgment debt. And I don't know if your lordship recalls that, but the original order that we had proposed to the court had one of the sanctions was that the defendant be ordered to pay the judgment debt within a specific time frame. And the reason for that was that it opened up the possibility of other execution methods like writs of sequestration. And the rules provide that you can't get that kind of order unless the defendant has breached a court order to do something within a particular time frame. So we had proposed that, and your lordship's view was that it was premature to think about that kind of thing until the set-aside applications had been determined. So I think the you know, apart from going through the background again, which your lordship doesn't need me to do, that was the only extra submission I wanted to make in relation to sanction, if that were a possibility. I can take you to the references to what we proposed before, if your lordship would like to have a look.
Is that in the transcript?
It's in the draft order that we originally.
All right, no, show me that.
That's at page 2189. I think it's a paragraph 3 of that order. No, it's not. That's the wrong order, isn't it? Sorry. I'll take it to the skeleton argument, which I do have the reference to. That was 2322. And we talked about this at paragraph 27 and 28. We'll find the draft order for you whilst we read that.
Yes.
And in your ruling at the hearing, the reasons for your committal order, you said it follows, I'm not going to make an order of that kind in paragraph 3 just yet. It seems to me that if there is to be an order which has a time limit which could enable sequestration of assets as opposed to simply charging the shares, that is a matter that should be dealt with appropriately at the time of the enforcement application being considered and determined. So we felt that was something that was left open, and I think we have the draft order is at 2168, and it's paragraph 3. Thanks. So the idea is that if the court fixes the time and has a penal notice attached to such an order, then a breach of it engages the right to the writ of sequestration. And we haven't followed through exactly how that would work. But one of the thinking is that the rental payments which come in may well be something that could be sequestrated, even if the shares could not be sold. So it's leave now. The payment of the entire judgment sum within a fixed time is a severe penalty.
Well, I suppose I was going to ask what it was you were hoping to sequester beyond the shares, but
and it's
yes.
not something that we necessarily will be doing immediately, but it's an alternative enforcement mechanism, perhaps, if the shares somehow cannot be sold.
This could enable you to sequester dividends.
Yes, indeed.
It wouldn't enable you to go beyond that to sequester the rent income, would it, as such?
It's not clear to me how it could be presently, my lord, the rent, but the dividends, perhaps in relation to the proceeds of the rent, may well be.
Well, I'd have thought the dividends plainly were. I mean, I'm thinking even on the arguments that were presented in relation to the statute that was operative in the Dubai court, which certainly said that dividends were capable of being executed against.
Yes,
in a sense that would be completely uncontroversial.
Yes, but perhaps the mechanism to declare dividends, which might correspond to the rental income, is something we haven't quite worked through. But
I understand that, but one rather suspects from the evidence that formal processes of that kind don't feature very largely in preceding practice of this company.
Yeah. Yes.
But there we are. Go no further. All right, but I guess the question then is 7 days to pay 90 million dirhams or whatever it now is in terms of interest, within principal and interest. 7 days. I mean, well, there has to be a degree of realism about this.
Yes, indeed. Although we really don't have any idea. There may well be significant other assets. You have seen Mr. Rashed's own witness statement where he says, "I own multiple properties in Al Fatah." There's another witness statement somewhere in the onshore proceedings where he says he's got significant assets in Iran, which we haven't been able to touch. But it's not beyond the bounds of possibility that this judgment could be settled by other assets beyond the shares, and that's probably what we're seeking this order to be able to access. I can see it's not straightforward, but and as a sanction
in the ordinary way, Mr. Holloway, one wouldn't expect anybody to be able to lay their hands on a sum of this size within 7 days. You'd have to take steps to realize assets, which could take, I don't know.
Yes.
Even with the best will in the world. I don't know, a month, 28 days. You can borrow quite quickly. I mean, I've had this recently in relation to a UK figure who was very wealthy, but in order to raise the money in loans and so on, it took him time. And 28 days seems to me to be a more realistic time against which it would be possible to go to a bank with your assets and say, let me have the money so I can pay this judgment.
Well, that there is a realism, an element of realism to that, but 2 points perhaps point towards a shorter time frame. The first is that the judgment was issued in 2016, so it's not like he's not had time to pay. And the second is that we're talking about here a sanction for contempt of court rather than a reasonable proposal for which settlement can be made. So perhaps, as I said, it's not for us to push for strict sanctions, but perhaps we could meet somewhere in the middle between.
Well, what's the downside in real terms, Mr. Holloway, if I give 28 days? Apart from the fact you've got to wait for 28 days, of course, but before you can get your writ of sequestration. But
yes,
I mean, time, I'm afraid the whole thing has taken so long that, you know, I'm inclined to give the defendants what it would be considered in ordinary parlance to be a reasonable time to raise the money. Maybe you could do it in 21 days. I'll say 21 days. 21 days, I think. You know, if he's got good bank contacts, he can go to a bank and he can borrow the money and he can put up security in whatever form he's got, even if he can't sell properties in Al Fatan or anywhere else, Polo or City Walk or whatever. Yes. All right. All right. So that's let's just make a note of that. And it's not for you to tell me what the right level of sanction is, but it's perfectly permissible for you to comment on what I have in mind. So my thinking was that I would impose a fine of $500,000 US, whatever its equivalent is in dirhams, if the contempt is not purged within 7 days.
Absolutely no comment on that at all, my lord. That's
I guess the fine should be expressed in dirhams rather than dollars, should it, or not? Any reason why it shouldn't be in dollars?
I don't think there is, my lord. I think it can be in dollars.
Right. So $500,000 if not purged within 7 days, and first defendant, and that's against the first defendant alone, isn't it?
Yes.
And first defendant shall comply with the enforcement order and satisfy the judgment debt within 21 days of the date of this order on further penalty of contempt. Right, so far what we have is application for adjournment or stay of the hearing refused, application for permission to appeal dismissed, sanctions for contempt, first defendant to pay a fine of $500,000 if contempt is not purged within 7 days, such fine to be payable immediately on expiry of that 7 days. First defendant shall comply with the enforcement order and satisfy the judgment debt within 21 days of the date of this order on further penalty of contempt. Yes. What else?
Costs.
Yeah.
We've submitted a cost schedule, and I believe it was sent to you this morning. It was filed yesterday in accordance with the rules, but I don't have a bundle page number for it. Perhaps.
I don't think I have that unless. Hayley, if you have it, can you send it to me by email immediately?
I will now, Your Honour.
Thank you. Yes, Delvin, sorry. Yeah.
That was sent, filed.
Can I just confirm if it's been filed under the PTA hearing bundle dated 28th of May, so that I can send the judge the correct?
It was filed on the ENF case file yesterday, but it was emailed to the registry also this morning.
Okay, I have it. Yes, on the ENF. Okay, thank you. I've emailed it to you, Your Honour, so you should receive it soon.
Yeah, just got it. Thank you. Right. So this is costs of what exactly?
Well, this permission to appeal process and the contempt application only. And the total is 223,000 dirhams.
I'm smiling because I was just doing a quick conversion and discovered I was using a conversion rate for Indian rupees, which I happen to have been thinking about in another context entirely, which is not very helpful.
Did that make it look
it's
bigger than?
It's about $60,000, isn't it? $61,000 near enough.
It's something like that. What, £45,000, I think.
Yeah.
My lord, so first point I'd make is the preparation for this hearing was done on the basis that we were having a full day of legal argument, with every possible point that was taken in the skeleton argument and the grounds of appeal and so on. It's not panned out that way. So obviously, for example, the attendance at the hearing, we did put 2 hours because we had a feeling it would not be the full 4 hours yesterday, but it's ended up being less. So that's fair enough to cut that down. But it was unclear to me, even this morning, what form this hearing. You know, I have prepared it on the basis that
you might have to do everything.
Yeah,
no, I understand.
These are the submissions that I had to read to you, and so
no, I understand.
There is that, and also I would submit it's plainly an indemnity costs basis and assessment because of the very nature of what's happened today and throughout. Apart from that, my lord, you often look at my work done on documents, which looks high, but it's in the context of this, I'm doing the partner role on this case and the counsel role, so there's quite a bit of work on the skeleton, the grounds of appeal, etc. at the beginning, and the prep for the hearing as well. So that's all I'll say on that. It's about a week's work for myself over a 6-month period.
Yes, all right. Well, as this day's gone slightly short, we'll make it a total of 213,000 dirhams.
Grateful, my lord. Thank you.
On the indemnity basis.
Thank you. I think the only other thing I wanted to say is that the order should have the penal notice on it, like the contempt order at least should have.
Yes, well, again, do you want to draft that and send that to the registry for approval? That would be the simplest thing.
So, my lord, will you be issuing 2 orders then? Would that be your plan to have one on the permission to appeal, a simple one, and the contempt one separate?
If that's easiest because of the penal notice point, that probably does make sense to have 2 distinct orders. One that deals with the application for adjournment stroke stay.
Yes.
And the application for permission to appeal. And then the other that deals with the contempt,
Yes.
the fine, the compliance with the 21-day order, so to speak. And how does the cost work? Which one does that go in? I suppose that goes in. Well, I think put it in both, that make it clear that it's only one order.
Yes.
Do you see what I mean? Yeah,
Yes.
goes in both as the total for all applications.
Right. Yes.
But is a summed. The 2 orders to be read together. You'll have to work out how to.
Yes. Oh, yes. We're not trying for double recovery.
No, exactly. But it's got to be plain on the face of the order that that it's one sum that's being referred to.
Would you like us to draft both those orders then to send?
Please, if you would, please. Yes. And what I will do, Mr. Holloway, is that I will attach some brief reasons in writing, which will repeat what I've actually said orally in the context of the refusal to adjourn or stay, but add something in relation to the refusal of permission to appeal on the basis that regardless of the matter not being progressed today, I would have refused it in any event for the following short reasons, which I'll set out. So that's so that the Court of Appeal has something else to look at in case they're short of reading material, should it ever reach them. Or indeed, I suppose, the JJC or whatever it's now called.
Yes, yeah, yes, indeed. My lord.
Yeah. All right. Okay. Nothing else then for the moment.
May I just briefly check in case there's any
Of course.
urgent communication from client, Mr. Anderson? No, thank you very much, my lord. Very grateful.
All right. Well, if you'd like to sign out again, then I'll have a quick word with the associates. Thank you very much indeed.
Thank you, my lord. Thank you.